Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. Today's episode will cover Rules of Court and Criminal Procedure. Rule 122, Appeal, Section 1. Who may appeal? Any party may appeal from a judgment or a final order, unless the accused will be placed in double jeopardy. Section 2. Where to appeal? The appeal may be taken as follows. A. To the Regional Trial Court, in cases decided by the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court. B. To the Court of Appeals or to the Supreme Court in the proper cases provided by law, in cases decided by the Regional Trial Court, and C. To the Supreme Court, in cases decided by the Court of Appeals. Section 3. How appeal taken? A. The appeal to the Regional Trial Court, or to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its original jurisdiction, shall be taken by filing a notice of appeal with the court which rendered the judgment, or final order appealed from, and by serving a copy thereof upon the adverse party. B. The appeal to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its appellate jurisdiction, shall be by petition for review under Rule 42. C. The appeal to the Supreme Court in cases where the penalty imposed by the Regional Trial Court is death, reclusion perpetua, or life imprisonment, or where a lesser penalty is imposed but for offenses committed on the same occasion, or which arose out of the same occurrence that gave rise to the more serious offense, for which the penalty of death, reclusion perpetua, or life imprisonment is imposed, shall be by filing a notice of appeal in accordance with paragraph A of this section. D. No notice of appeal is necessary in cases where the death penalty is imposed by the Regional Trial Court. The same shall be automatically reviewed by the Supreme Court as provided in Section 10 of this rule. E. Except as provided in the last paragraph of Section 13 Rule 124, all other appeals to the Supreme Court shall be by petition for review on certiorari under Rules 45. Section 4. Publication of Notice of Appeal. If personal service of the copy of the Notice of Appeal cannot be made upon the adverse party or his counsel, service may be done by registered mail or by substituted service pursuant to Sections 7 and 8 of Rule 13. Section 5. Waiver of notice. The appellee may waive his right to a notice that an appeal has been taken. The appellate court may, in its discretion, entertain an appeal notwithstanding failure to give such notice, if the interests of justice so require. Section 6. When appeal to be taken. An appeal must be taken within 15 days from promulgation of the judgment, or from notice of the final order appealed from. This period for perfecting an appeal shall be suspended from the time a motion for new trial or reconsideration is filed, until notice of the order overruling the motion shall have been served upon the accused or his counsel, at which time the balance of the period begins to run. Section 7. Transcribing and filing notes of stenographic reporter upon appeal. When notice of appeal is filed by the accused, the trial court shall direct a stenographic reporter to transcribe his notes of the proceedings. When filed by the people of the Philippines, the trial court shall direct a stenographic reporter to transcribe such portion of his notes of the proceedings as the court, upon motion, shall specify in writing. The stenographic reporter shall certify to the correctness of the notes and the transcript thereof, which shall consist of the original and 4 copies, and shall file the original and 4 copies with the clerk without unnecessary delay. If death penalty is imposed, the stenographic reporter shall, within 30 days from promulgation of the sentence, file with the clerk original and 4 copies of the duly certified transcript of his notes of the proceedings. No extension of time for filing of said transcript of stenographic notes shall be granted except by the Supreme Court and only upon justifiable grounds. Section 8. Transmission of papers to appellate court upon appeal. Within 5 days from the filing of the notice of appeal, The clerk of the court with whom the notice of appeal was filed must transmit to the clerk of court of the appellate court the complete record of the case, together with said notice. The original and 3 copies of the transcript of stenographic notes, together with the records, shall also be transmitted to the clerk of the appellate court without undue delay. The other copy of the transcript shall remain in the lower court. Section 9. Appeal to the regional trial courts. 8. Within 5 days from perfection of the appeal, the clerk of court shall transmit the original record to the appropriate regional trial court. B. Upon receipt of the complete record of the case, transcripts and exhibits, the clerk of court of the regional trial court shall notify the parties of such fact. C. Within 15 days from receipt of the said notice, the parties may submit memoranda or briefs, or may be required by the regional trial court to do so. After the submission of such memoranda or briefs, or upon the expiration of the period to file the same, the regional trial court shall decide the case on the basis of the entire record of the case, and of such memoranda or briefs as may have been filed. Section 10. Transmission of records in case of death penalty. In all cases where the death penalty is imposed by the trial court, the records shall be forwarded to the Supreme Court for automatic review and judgment within 5 days after the 15th day. Following the promulgation of the judgment or notice of denial of a motion for new trial or reconsideration, the transcript shall also be forwarded within 10 days after the filing thereof by the stenographic reporter. Section 11. Effect of appeal by any of several accused. 8. An appeal taken by one or more of several accused shall not affect those who did not appeal, except insofar as the judgment of the appellate court is favorable and applicable to the latter. B. The appeal of the offended party from the civil aspect shall not affect the criminal aspect of the judgment or order appealed from. C. Upon perfection of the appeal, the execution of the judgment or final order appealed from shall be status to the appealing party. Section 12. Withdrawal of appeal. Notwithstanding the perfection of the appeal, the regional trial court, metropolitan trial court, municipal trial court in cities, municipal trial court, or municipal circuit trial court, as the case may be, may allow the appellant to withdraw his appeal before the record has been forwarded by the clerk of court to the proper appellate court as provided in Section 8, in which case the judgment shall become final. The regional trial court may also, in its discretion, allow the appellant from the judgment of a metropolitan trial court, municipal trial court in cities, municipal trial court, or municipal circuit trial court to withdraw his appeal, provided a motion to that effect is filed before rendition of the judgment in the case on appeal, in which case the judgment of the court of origin shall become final, and the case shall be remanded to the latter court for execution of the judgment. Section 13. Appointment of counsel de officio for accused on appeal. It shall be the duty of the clerk of the trial court, upon filing of a notice of appeal, to ascertain from the appellant, if confined in prison, whether he desires the regional trial court, Court of Appeals or the Supreme Court to appoint a counsel de officio to defend him, and to transmit with the record on a form to be prepared by the clerk of court of the appellate court a certificate of compliance with this duty and of the response of the appellant to his inquiry. And that is the end. If this audiobook has helped you, please comment down below and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.